I'm Georgina Jalbo from Lexis PSL Private Client, and I'm joined today by William Healing and Jane Keir, partners in the family team at Kingsley Napley. And William and Jane are going to talk to us about the topical subject of privacy in the family courts, and in particular how to protect the privacy of high net worth individuals and those in the public eye in family proceedings. So thank you very much for coming in today. Jane, could you start by explaining whether privacy is still assured in the family courts?
The short answer to that is that it's not assured in the family courts, and for many clients the last thing they need to think about when they're facing a divorce is whether what they say or write is going to find its way into the public domain. The family procedure rules do provide for proceedings to be held in private, but it is then possible for the media to make an application for reporting restrictions to be lifted, which means that if that application is successful, then they can come into court and may be able to report what's actually happening. There's been a lot of momentum towards opening up the family courts because there have been criticisms about it being secret and that not being in the interest of justice. And those moves are really championed by the President of the Family Division, Sir James Munby, and Mr Justice Holman, who believe that proceedings should be held in open court and that access should be given. The opposing view comes from Mr Justice Mostyn, amongst others, and his view is that financial proceedings are quintessentially private, and that where someone is being compelled to give information about their financial position, then they should have the safeguard of proceedings being held in private. So we do look for, or clients would be well advised to look for alternative means of having their differences resolved. So William will talk about what the various proceeding processes are, but we have mediation, arbitration, collaborative law. But it is sensible, as I say, to try and find a way to avoid having to go back to court because your privacy can't be guaranteed. And as I say, it's a real headache to be thinking about, you know, am I going to be quoted in the press? And if you're a celebrity or there's a lot of money involved, then that's a real risk and one that you would really want to avoid.
Okay, thank you. Well, given that the position isn't very clear-cut, William, do the courts find the rules easy to apply in celebrity divorce cases, and is there any certainty from case to case?
Not really, and both the judges and the lawyers, on the other hand, are finding the rules difficult to fathom. For example, recently in the Liam Gallagher and Nicole Appleton divorce, there was an application of the kind that Jane mentioned by the press to lift reporting restrictions, because the basic rule is that although accredited press can go in, they can't report fully on proceedings. And Mr Justice Mostyn, whom Jane referred to, who's on the sort of privacy side, described the media reporting rules as a complete mess. The position has been since 2009 that, as I said, accredited members of the press can go in. The problem is they can't get a juicy story out of the case because although they can go in as what Jane called the watchdog, what they can't do is report on details of the case. They're not allowed to have access to the papers, and they can't identify the parties involved in the case. So that doesn't make for much of a press story. Right. So unless they go in and make the application of the kind that they've made in the Gallagher-Appleton case to push the doors wide open, they're not going to get a story out of it. So they need to go in and make these applications. And when they did that before Mr Justice Mostyn back in September, they applied for the permission to have full details of the parties and the topics of the evidence that were being discussed. Mr Justice Mostyn granted those applications, but didn't allow financial details, for example, of Liam Gallagher's company to be reported. So they weren't able to get down to the nitty-gritty. The judge was in something of a difficulty because, as is so often the case in these celebrity situations, the cat was out of the bag on social media and in the traditional media as well, with many details of the case already reported and widely discussed. So Mr Justice Mostyn felt to some extent his hands were tied and he needed to reveal more information about this case or allow that to be reported.
Okay. Thank you. So what if the client wants detailed disclosure? Is it really possible to keep a case out of court?
Very often cases will start off on a contested basis, and given that our law looks to see whether an equal division of a couple's capital assets is a fair outcome, then there's a lot of time and effort spent on establishing, well, if 50% is a fair outcome, then 50% of what? So you need to know the full extent of a couple's financial resources. And although both parties are under an obligation to give full and frank disclosure of their financial position, sometimes you find that perhaps one party is rather more reluctant to do so because for various reasons. I mean, sometimes they're concerned about possibly tax considerations, and maybe they feel that it's very unfair that they're being put through the process in the first place. But the courts have a wide range of powers that they can engage in relation to making sure that they find out the full extent of the assets. So you can sort of have a halfway situation whereby the parties rely on the court process to establish the full picture, but when they reach the stage whereby they can start to negotiate, what very often you find is that they will opt out of the formal court process at that stage and go for what we call a private, it's called a financial dispute resolution meeting. We're called FDR for short, and they will opt for what we call a private FDR. So they will choose someone to conduct the FDR appointment. Might be a retired judge, it might be a senior practicing barrister or solicitor, and they will choose a day and they will have that person to themselves so they can put all their arguments forward. They're guaranteed that person will be available on the day, because quite often in the court process you have 5, 6, 7, 8 cases in the list, and if you're 7 or 8 you might not be reached in the day. So with your private FDR, the idea is that you have all the time that it takes with the full attention of your private judge to put your arguments before, and then he or she will spend time saying, well, in my view, this is the conclusion that I would reach, this is sort of the award that I would make. And you can go back outside, you can negotiate, you can come back in, you can get a further view, you can spend, you know, much of the day there, and they are proving very effective at helping the parties to reach agreement. So it's a very good way of using the court process to get your disclosure and then saying, actually, we really do want to ensure confidentiality around this negotiation process. So we will appoint a private judge and we will have an appointment, and if we reach an agreement, then we can put that back before the court to make an order, but you spare yourselves the possible ordeal of, again, the media. Possibly it would be a negotiation appointment, the media would be unlikely to be given access, but it's still all the build-up and all the stress that can attend having the media, knowing that the media are interested in your case. So the private FDR appointments are very popular.
Yes, yeah, that does sound like a very good option for clients.
It's very sensible.
And are there any other out-of-court routes?
Well, yes, there are. Obviously, the most basic level of out-of-court negotiation is the classic exchange of solicitors' letters, and then you can go one up from there in a more involved negotiation and have possibly a roundtable meeting with lawyers on each side and clients, usually in attendance as well, so what we call a four-way meeting. Then the other routes, the other classic out-of-court dispute resolution models are mediation, arbitration, and collaborative law. And I'm going to spend a little bit of the answer, if I can, talking about the mediation route, because that seems to have been the most enduring and the most popular of the three. Collaborative law and arbitration have had, for reasons I can come to, had trouble lifting off to the same extent. Mediation's been around longer and involves both parties hiring a mediator, who very often is also an experienced lawyer. So they take off their lawyer hat on that day and they're a mediator. And the process works in the following way. The parties will set together a detailed agenda, their agenda, so it's very much client-driven, rather different maybe from where the lawyers take over, and they will explore with disclosure that agenda and get to the bottom of that. And then the mediator, particularly if they've got a lawyer background, will be able to generate options for them and say, well, in the framework of the law, this option will work, or this option will work best for you, I think, what do you think? And then perhaps most importantly of all, towards the end of the mediation process, which is something I do when I mediate, is that the mediator will reality test, because you've got to know that the judge is going to approve the settlement, and B, that it's going to work in the context and using the experience of the other cases the mediator has been involved with. And mediation is suitable for big asset cases, intractable, really difficult disputes. For example, the Court of Appeal have run a mediation scheme for difficult cases for a number of years, where they send out cases that have got to Court of Appeal level out for mediation. And it even works in international cases as well. Increasingly in mediation, lawyers get involved. Now that may sound like a bad thing, but actually lawyers being involved could be a good thing, because it can give parties confidence if they've either got the lawyers with them in the mediation room. There can be no speaking rules apply to the lawyers sometimes, and other models involve the lawyers being in an adjoining room so the client can go out for advice. And lawyers are very often or usually involved in the disclosure process of mediation to make sure there's a really full and robust exploration of the details and the documents and information that support any legal case. And I'll just add one more thing to that, which is that when going to court now, for those cases that do go to court, the parties are required to go and see a mediator to be able to show the court system that before they issued their court documents, that they have been to spend 15 minutes with a mediator to be explained the mediation process. They don't then have to go on and mediate, but it's a requirement now to have an introductory session with a mediator to know what mediation's about before you can go to court.
Okay, thank you. And one last question. With the austerity cuts to the Ministry of Justice, are the courts the subject of delays? And also, what are the other advantages of out-of-court solutions?
There have been delays, there are delays in relation to the sheer volume of cases coming before the courts. And so if it's the same amount of resourcing or less resourcing because the cuts have impacted, then you can see with a greater number of cases coming in front of the courts that delays are going to be inevitable. Add to that mix the fact that we have more litigants in person because legal aid or public funding has been cut back so badly. You've got quite a serious mix, and not a mix for the good in terms of our waiting lists and people actually getting access to judges. Now, there are measures have been put in place to try and help mitigate some of the question of delay. So for example, whereas a few months ago we would be sending our paperwork to the Central Court in London to be issued and dealt with, most of it is now sent off to a centre in Bury St Edmunds. So, you know, the court system is trying to address these difficulties and these issues, but it's nevertheless, I think, still swamped by the high number of cases that are coming in front of it, and most of those are children cases, and finance cases tend to take second place, but nevertheless our judges are very busy full time and their lists are very full, and the system is still creaking.
Yeah, I've had a case recently, to add to that, I've had a case recently where we were supposed to have a final hearing listing on a very delicate children matter in recent months, and we would turn up at court and we weren't allocated the level of judge we were told we were going to have, so there was an administrative error and we were sent away, and the parties fortunately have been able to reach a deal now on returning to court. We reached a deal at the doors of the court, but what happened was, in effect, my client had to pay, or both parties had to pay, for lawyers going to court twice. And so we've got a large compensation claim before the court for the wrong listing. Now, mistakes like these are being made as a result of the resourcing pressures that Jane is talking about. And just there's also the sheer length of time it takes for cases to run through the court system with all these pressures. So some of the options we've been talking about today offer clients the real possibility of resolving their dispute in about 3 to 6 months, perhaps tops, as opposed to 12 to 18 months through a court process. And just finally on dispute resolution, there's lots of research shows that out-of-court settlements or even settlements reached at the doors of the court will result in a more lasting solution for the parties, and that can be very beneficial, particularly for children, if the adults don't lose the parenting cooperation skills that are so essential, that those can be damaged by going through a full court process right to final hearing. And Jane and I have seen that damage, and it is to be avoided.
Well, challenging times for the courts, but good to hear that there are alternatives to the overcrowded court system for clients. Thank you very much for coming in today, William and Jane.